to then this distinguished panel and tell you that a little bit how it's organized. We'll have 2 rounds. We will have 2 rounds, one of around approximately 25 minutes on competition policy and advocacy actions, and the second round focusing more on enforcement. And all of our panel members will have the same amount of time, even if it might be distributed slightly differently amongst the 2 rounds. And then there'll be opportunity for Q&A. So please do again, let us know your questions in the Q&A function, and we'll try and ask as many questions as we can in the Q&A section. So I'm very pleased and honored to have an excellent panel of heads of agencies that I will now introduce in order of appearance. So Olivier, in order of appearance in the roster, let's say. So Olivier Guersent is Director General of DG Competition at the European Commission. Margarida Matos Rosa is President of the Portuguese Competition Authority. Andreas Mundt is Chairman of the Bundeskartellamt, the German Federal Competition Authority. Cani Fernández is President of the CNMC, the Spanish Competition Authority. And last but not least, of course, Acting Chairwoman Rebecca Slaughter of the US Federal Trade Commission. So before we hear from our distinguished panel, let me offer a few words of introduction, just building on some of the main insights from the OECD on how competition policy can and should be part of the solution to the current crisis. And I'll base my words on the background paper that I co-authored on the role of competition policy in economic recovery, and that was released in December, and that you can find online. So let me start then with give just a few numbers to offer you some perspective of what we're facing. Our OECD Economic Outlook, released in December, it really shows a daunting picture. The world economy contracted by 4.2% in 2020. This is really unprecedented since the Second World War. And we saw a decrease of 3.7% in the US, 7.5% in the euro area, for instance. And governments have responded to the crisis with swift and equally unprecedented support measures, a little bit what mentioned also Professor Mazzucato before, in the order of $14 trillion in relief packages, around 14 to 15% of world GDP. And that's just so far. And today's policy response will have a major impact on our ability to exit and recover from the crisis. And therefore, it cannot be short-sighted. And in this context, we believe that competition must be taken into account in a wider policy agenda for recovery. Given the brief time, let me just focus on 2 points from the background paper. The first one is that looking at previous moments of big economic hardship, such as the Great Depression, the Japanese crisis of the 90s, the global financial crisis, we've learned that lax cartel enforcement and merger control in times of crisis holds back recovery. Therefore, raising awareness of the benefits of competition and advocating for competition policy is really more important now than ever. The second point I want to make is that we must ensure governments respect the principles of competition when it comes to the deployment of state support, and that competition authorities are well placed to provide advice to governments in designing support measures to ensure that they do not unnecessarily distort competition. And by using such powers, they can help governments make a better assessment of the potential costs and benefits of possible alternative policy measures. So less carefully crafted state support actually risks leading to unintended consequences on markets, distorting competition and harming market efficiency with long-term impacts. And this becomes ever more relevant as countries attempt to better target measures in what is now, will hopefully be soon, the recovery phase, in particular in the context of an increasingly constrained fiscal space. So what specific recommendations can competition authorities make when advocating in the context of state support measures? And let me give you 3 examples from our paper. The first is that competition authorities should advocate for the state support measures to be proportionate. And this can be done through a counterfactual analysis, much like in merger control, comparing the situation with the scenario where, with the current situation, with the scenario where COVID-19 would not have occurred. So selective support measures may well be appropriate for sectors where the crisis will likely only have a temporary negative effect. It might be, however, more problematic for sectors experiencing a permanent shock, either because of the COVID pandemic directly or from policy choices such as green policies. So such support risks artificially preserving an industry or sector that is in decline. In such cases, state intervention could rather focus on measures aiming at scaling down and restructuring instead. Secondly, if competition authorities identify cases where the support measure would most likely bring competition distortions that would outweigh the positive effects, the competition authority may advocate for the government to require certain compensatory measures or remedies as a condition for the state support in order to help reduce barriers to entry and help reduce market power. And these proposed remedies may be structural in nature, for example, requiring a divestiture of assets, or behavioral. A third and last example of recommendations competition authorities can make to governments on state support is to advise on exiting the support measures to ensure competition-friendly exit from the crisis. Competition authorities may provide support to policymakers by ensuring that a number of elements are taken into account, including sunset clauses in the design of the support measures, and ensuring that the exit of any recapitalizations through privatization is undertaken by open, transparent, and non-discriminatory processes. So finally, a few words on enforcement. This is always important, even more so in times of crisis. Many competition authorities have significant discretion in which cases to pursue or which sectors to analyze and where to focus their enforcement powers. So competition authorities may have to redirect enforcement towards strategic markets and strategic industries that might lie at the heart of the recovery process in their particular economy. So we think that competition authorities should participate in assessing the cost of competition of state support measures, and by redirecting enforcement resources towards markets and industries that are important for the recovery. So I encourage you to read our paper to find out more detail on what competition authorities can do to help the economic recovery. But I'm very keen now to hear from our heads of agency panel and to know how the recovery is being embedded into their priorities, how it is being embedded into their interventions. So I'm going to move now on to the first round, which is the advocacy and competition policy round. And I'm going to start with Olivier Guersent. Olivier is the Director General of the European Commission, DG Competition. And the EU is one of the few jurisdictions that has enforcement powers of state aid or certain forms of state support. So you have a very well-developed system for analyzing state support measures that may distort competition. You have a temporary framework that you put in place to deal with state aid cases in the context of the current crisis. And so I was wondering if you could tell us what the principles underlying the temporary framework to reduce distortions of competition are, and to what extent the temporary framework can help maintain the situation before the crisis rather than actually enabling a digital and green transition. So, yeah, Olivier, please.
Okay. Can you hear me?
Perfectly.
Okay, very good. Well, the temporary framework was created because, of course, faced with an unprecedented crisis like the COVID crisis, the first emergency was to secure liquidity assistance for companies. The analysis we made was that we need to preserve the productive capacity of companies so that they can restart and they don't have to rehire, reskill, and or reinvest. So that was the premises on which we've been acting. Of course, this is all the more effective as you have a kind of a peak crisis, a climax, and then things come back quickly to normal. And this is not quite what we had. This is what we expected in the beginning, if you remember. But of course, this type of policy becomes extremely expensive when you maintain it a very long time. And also because very soon, what you see is new needs appearing in terms of solvency restoration, because even if you give some or even some considerable liquidity assistance, at some point the solvency situation of firms deteriorates, and you need to move into the area of solvency support. So this is what we've been doing. We are now at the fifth iteration of the temporary support, and the idea here is really to try to limit the aid to the stated objectives that I've just explained. in order to avoid several undesirable effects. The first one is, of course, to have too many zombie companies on the market. That is in a way unavoidable. You can already see that in quite a number of member states, the rate of bankruptcies in 2020 is lower than in any year before, which indicates that probably we have zombie companies hanging around. And for as long as this remains limited, probably it's an unavoidable side effect of this type of policy. The second thing we wanted to avoid is to try to limit the fragmenting effects on the single market. Because of course, I mean, our single market, as we experience now with Brexit, is probably our dearest, our greatest good in the EU. This is what clearly fuels growth. And the more fragmented it is, the less efficient and effective it is in allocating resources. So there we took two things in consideration. The first one is that although the crisis was global and hit everybody, it didn't hit everybody the same because it's much dependent on the structure of the economies. If your economy is much dependent on transportations and tourism, you will be hit differently than if it is comparatively less. So the share of your GDP that is derived from activities that are most hit by the pandemic is an important factor here. And it has in itself fragmenting effect. And the second fragmenting effects come from the cure itself. Because of course, we were hit as we were just emerging from 10 years of financial crisis and euro crisis. And some economies sailed better than others throughout this crisis. So they're more resilient than others, have more fiscal space for intervention. Therefore, the nature and the amount of the intervention creates fragmentations in itself as well. To give you an idea, we have authorized more than 3 trillion of state aids in the EU, which is pretty much unprecedented. Its authorization is far from what has been spent, of course. It has to be understood. 80% of these have been authorized for 3 countries. So 3 countries account for 80% of this 3 trillion, and these are Germany, France, and Italy. And the rest, so the 24 remaining, account for the remaining 15%, 15 to 20%. So that's quite interesting in itself, but in terms of the fragmenting effect. The second aspect is qualitative. As if you're Germany, you have more resources to give direct grants. If you're Italy, you will more revert to loans because you have less fiscal space. So this is what we see, with France in the middle. This is also something we took into consideration, and this is what led us to propose the Recovery and Resilience Facility, because in order to try to limit the fragmentation effects that are linked to the different capacities of the member states. Now, my last point is now we are moving, or we will soon be moving to the third part, which is basically recovery. And in my view, this is where, I mean, it is clear that when you are at the level of liquidity assistance, there is no question of conditionality in order to align on the longer terms. But what it is about is basically saving the companies short term. Already at the stage of solvency restoration, you can think that some light conditionality, because you don't want to restore the solvency of companies that are going against your long-term objectives. Now, when you move into recovery, the alignment on your long-term objectives of decarbonizing the economy, of managing the upscaling in terms of digital, that becomes a lot more important. And this is the phase we're entering now. Thanks.
Okay, thank you, Olivier. I mean, I had a couple of questions maybe to follow up quickly on this. I mean, one is on the role for conditionality, which you just mentioned there. Is there something more you can tell us about the role of conditionality, how it might change in the recovery? And the alternatively, or the other question I had was regarding the role for DG Comp in the next generation EU fund. For those who don't know, the next, you mentioned the facility. This is a European-wide recovery fund for 750 billion euros to allocate grants and loans to member states for precisely the economic recovery. So perhaps you can tell us a little bit about the role for competition policy. Presumably it's more linked to advocacy, I'm not sure, but maybe you can tell us, and then whether there's linking that to conditionality eventually.
Well, in terms, excuse me, I'm plugging my iPad because otherwise I will collapse in a minute. I hope it works. Yes, it does. Okay, I'm back. So in terms of conditionality, well, that is quite clear. I mean, we do not want that our short-term actions or medium-term actions in terms of recovery run counter or long-term actions. So what we've been doing are two things. And it's a bit more than advocacy, because as you said in your introductory remark, we have enforcement powers in the field of state subsidies. So the first one is to think in terms, and we are carrying this work with the member states at the moment. Is there a gap between the mere adaptation of the long-term rules, which we're doing? We are engaged in the biggest ever review of all our rules, in particular in state aids. So the environmental guidelines, how we, etc. So should we allow green bonuses, for example? Under which conditions? I mean, all these questions are very heavily debated. And Mrs. Vestager has launched a big exercise of requesting contribution. We received more than 200 about how the competition policy can contribute to the Green Deal objectives, for example. And now we are adapting the long-term rules in order to foster innovation and address market failures in the areas of the twin transition. So the transition towards upscaling digital and decarbonizing. And as was told during the introductory remark, it's all about innovation, really. So how do you focus your state support where there is a market failure? So in other words, it wouldn't happen absent state support, otherwise you waste your money, of course. And in innovations that will make a difference in terms of meeting our objectives more quickly. So this is basically what we're doing at the moment, and that will result into a number of conditionalities or a number of modalities. If I give you an example, for example, in the past we said, okay, well, you can basically give support to a renewable quite big time, but you have to auction it. And what we saw as a result of this policy is that the price and the cost for new construction of windmills dropped very, very quickly, minimizing the necessity for public support and maximizing the utility in terms of the general public. So that's one thing. The second thing, and I finish with this, is there a gap? So is there a gap between, is it fine that you simply adapt your long-term rules, or are there things that are desirable to be allowed during the recovery that you would not like to allow over a longer term? And in other words, should we move to a crisis temporary framework to a recovery temporary framework? Of course, it's not that binary because it's a continuum. So depending where you are, in which sectors in the EU, you may still be at the liquidity assistance stage, or at the solvency, or at the recovery end.
Thank you very much, Olivier. Well, I'm sure we'll have opportunity to dig a little bit deeper into some of these topics. I would like to move on to Margarida Matos Rosa. And I know that the Portuguese Competition Authority has really had a really hard look at priorities and considered that the economic recovery is really high up on your list. And what can you tell us regarding the focus of your advocacy work in the specific context of the economic recovery?
Thank you, Ruben. And first of all, I need to really congratulate the OECD for having this third edition, if I'm not mistaken, of the OECD Competition Day, because I think it's a really important opportunity that it has created to reach out beyond a specialist circle to anyone interested in the topic of competition and in its benefits. So congratulations to the whole OECD competition team. So just a year ago, we met before really the onset of the first wave of competition, first wave of COVID-19, and we had scarce visibility on the economic upheaval that was going to take place really throughout the rest of the year and beyond. And a year on, as many of our countries are experienced the third wave, we meet again, and this time to discuss the role of competition policy in the economic recovery. And a massive recovery effort will certainly be needed, not like a recovery from a cyclical economic downturn, rather like a recovery from a major shock. We all know this, of course, but recovery effort does not mean necessarily financial support. It means much more, in my view, and that includes reform that fully allows companies and individuals to innovate and to demonstrate their unique skills. So my first point is that for the recovery to be as ample as possible and for competition policy to be at its core, we will need enforcers, of course, to be active. It's never enough to remember that competition is what drives productivity and innovation. And it is also at the core of the transformation that we aspire to towards digitalization and towards sustainability, for example. We need, therefore, more and not less competition, as you mentioned at the beginning in your introduction, so that we ensure that we come out of this challenging process much better, much stronger, and much more resilient. But it is important to keep in mind that because of the strong waves that are against competition law enforcement and the strong enforcement, will continue in face of times of crisis. We won't succeed, of course, in putting competition policy in every policy measure, every public policy measure. But my second point is that as enforcers, we should focus our advocacy in those efforts that require much more effort so as to enable a stronger and faster recovery. And I will address, if you allow me, three here: connectivity, labor markets, and state intervention. These have been areas that have marked the Portuguese Competition Authority's activity in 2020 and certainly guided our priorities for this year. So first, connectivity. We're at a time, of course, where consumption patterns are adjusting and consumers cannot be prevented from switching, or should not be prevented from switching, for example, from telecom providers that we need so much. And therefore, an example of our advocacy effort was last year in a paper that we issued regarding loyalty clauses in the telecom sector that create serious constraints in our market to consumer switching. And why is all this important? Because for consumers, freedom of choice and of switching in the telecom sector is even more critical today. Connectivity took an even more central role for us. It was already very much present in our lives, but it's even more important now. We depend on it for our roles in academic life, or our professional life, or our social life. So at the same time, while we did this, we also looked at the critical moment that we were living in the telecom sector, and we had some recommendations done for improving competition in this sector. Why? Because the critical moment was exactly that of the 5G spectrum auctions. Many are still undergoing in many countries, by the way. And the outcome of these spectrum auctions determines to a significant extent what our markets will look like for the years to come. And with that in mind, and given the lack of competitive dynamics that we found in the sector through our study, the ADC, the Portuguese Competition Authority, recommended measures to promote entry in the Portuguese telecom market For example, we argued for the inclusion of 5G frequencies in the bidding stage reserved for new entrants. Now, the second priority area is labor markets. It had already been in our radar, but in times of crisis and a strong job loss, flexibility becomes even more important. Professionals need to have the opportunity to adapt to new conditions in the market. In other words, they need to be able to change careers if they need to. And it's therefore very important that the legal and regulatory framework does not create unnecessary obstacles for workers that seek to change trades. And this is why the ADC has been advocating to remove unnecessary barriers on regulated professions. And this, of course, follows on the recommendations issued by the OECD in 2018 after a 2-year project developed with the ADC. The removal of these barriers has been envisaged, and that's a positive, in the Portuguese government's recent Recovery and Resilience Plan, currently under public consultation. So we really think it's important to do that now, remove obstacles now when a lot of people are out of jobs or will be out of jobs and will need to convert possibly to another profession. Or a similar profession, but with unnecessary obstacles for the time being. A third area of priority action that is state intervention. In my view, competition agencies can and should play a key role in advocating for competitive neutrality of state intervention. It's important that enforcers warn about the risks of picking winners and losers, or that they raise a red flag when public measures can lead to distortions of competition in the market. The objective, of course, is to be able to reconcile the underlying policy goals, especially those that want to promote economic recovery, while minimizing distortions of competition in the market, because this may compromise, of course, efficiency and consumer welfare, both in the immediate and in the long term. I'll give you just a very brief, or a couple of examples very briefly from the ADC's initiative, and then I'll stop. One of them was advocating precisely for technological neutrality in the payment services field. We had taken last summer a large-scale survey on fintech, and we found that new entrants still face legislative and technical hurdles when they try to provide several financial services in Portugal. So through the public stimulus measures that are being put in place, and which are run, by the way, through payment services, we think that they should encourage competition and innovation and be technologically neutral. And we regularly advocate this. Another initiative, final one, was an opinion issued on a recent government proposal to amend the Public Contracts Code. We expressed concerns as to the risks for competition and efficiency of an increased use of direct procurement awarding, even in those procedures due to the needs caused by COVID-19, because that direct procurement award is, of course, detrimental to a wider, compared to a wider competitive procedure. And I'll stop here, Ruben.
Thank you very much, Margarida, for that very interesting look at a number of very pertinent topics on advocacy, the connectivity, the labor markets, and the fintech. They all seem to be very, very important initiatives. So thank you for that, for sharing those. I now turn to Andreas Mundt of the Bundeskartellamt, the German Federal Competition Authority, and to tell us how the Bundeskartellamt has applied competition policy and its advocacy powers with the view to supporting the economic recovery, or what role you've had in this context.
Yeah, Ruben, many thanks for the invitation. Thanks for having me here today. I mean, competition and the economic recovery, indeed, I'm very, very happy to speak about such an optimistic topic. But it also touches, for the time being at least, also at a very sore point, because, I mean, times remain difficult for the time being, for individuals, for businesses, for the society as a whole, but also, of course, for competition and competition agencies. These are quite unusual times. I think we as competition agencies, we are well advised to keep our role, to maintain our role as good as we can in a very unusual environment. Why is the environment so unusual? It's just as simple as that market forces don't work as they usually do in these times. And what we see instead is states taking the initiative. We see state subsidies, state aid. We have a vast debate about industrial policy, about industrial strategies. We see cooperation between competitors which go along as normal as if maybe competition law did not exist. What I want to say, we have a strange climate for the time being, a climate in which competition law and the work of competition agencies is not so easy to uphold as we are used to. Maybe let's put it this way. I mean, this also comes from the fact that we ourselves have to adapt our work to a changing economic environment as well. Which for my part does not mean that we are lenient, but we just find a different economic environment. We do not find competition working as well as it usually does. And we always have to keep in mind that the basic rules still apply. You named them in your introductory speech, Ruben. That is, all measures that we take need to be appropriate and proportionate. They need to be non-discriminatory, and maybe most important, they need to be limited in times of crisis. I give you an example of the application of the law in Germany on that later. So my clear message today is we must be very careful not to get used to measures that are appropriate now, but they will not be appropriate after this crisis is over. I think also we as competition agencies, we should act differently with regard to the instruments that we have at hand. To give you an example, personally, I'm pretty relaxed with regard to cooperation among competitors because that can be limited, and that will run out after the crisis has come to an end. I'm not so relaxed with regard to mergers because mergers are about the future. They are structural. They change the market environment constantly. So I think we are very well advised not to give way here. I'm very relaxed with postponing a dawn raid in a cartel matter. Usually I can do that later on. But I'm not at all relaxed letting an abuse case go slower, especially in these difficult times where digital companies, the big techs, benefit like this from the concrete situation. And we have made that clear constantly in our statement. A last challenge maybe for the time being is that the pandemic fuels and accelerates market consolidation in some sectors. We see a difficult market development in some areas that might lead also to delicate mergers in some areas where jobs might be at stake in these times. Olivier has mentioned already some industries where the pandemic has hit hard on the companies. So this is the environment in which we live. We have a colleague in the European Competition Network that has already spoken of the crisis of competition. I would never go so far and say that we have a crisis of competition, but one thing is clear. For policymakers, usually competition is not on the top of the agenda. For the time being, it's state intervention. Still, it's how the state can act, how it can help in these times. But I think as soon as this crisis, as the pandemic slows down, we will be in a situation where we desperately need competition in order to gain back economic recovery. So I think we have to pave the way for that time as competition agencies. And this is our task in articles that we write, in speeches that we give, and maybe in meetings just as today at the OECD.
Yes, indeed. Thank you, Andreas, for that. Indeed, I mean, you talked about digital quite a bit, and of course, it's it's one of the big interesting questions at the moment is that there's been a significant amendment to your competition law with new powers that you have as regards digital markets, and I was hoping that you might be able to share with us what some of those changes actually bring in your view, and if perhaps that might mean a more that we'll see more cases in this area in the near future.
Yeah, indeed. The amended German Competition Act has just come into force by the end of January. For the time being, I would say we are taking breath now. You will hear from us in due time. I must say we have already achieved significant successes in recent years. Just to give you a very, very practical example, these days in Germany, we see a growing number of successful civil claims of sellers on the Amazon marketplace against Amazon. They are civil claims due to the fact that their account has been closed, that Amazon is withholding money on that account. And the fact that these civil claims can be brought in Germany at all is a result of our successful proceeding back in 2019, because until then, as a seller on the marketplace, you had to go to a Luxembourg court and fight for your right under Luxembourg law. I mean, good luck to these small sellers on Amazon in Luxembourg. So you see, we have already achieved some issue also in the Facebook case. We are very confident that we will be able to enforce that after we have gone through the court proceedings now. The key element of the amendment was a modernization of abuse control. We have a new provision that is Section A, a novel provision that is addressing undertakings with paramount significance for competition across markets. You can easily compare that maybe to the UK formulation of companies with a strategic market status. We can prohibit behavior on markets to these companies once we have them addressed in like this, where they have no dominance yet. So that is meant to address ecosystems of digital conglomerates. The law has clearly shaped certain kind of conduct that we can prohibit in the future. Theories of harm, if you want it to be like that, like self-preferencing, development strategies, hindering interoperability with regard to data. So there are clear-cut theories of harm that might facilitate our proceeding in the future. It's pretty close to regulation in a sense, but it's still competition law, or deeply rooted in competition law. These proceedings might be faster because there's one key issue. The Federal Court of Justice will serve as the first and last instance with regard to this new provision. So this alone might save us 1.5 years in proceedings if we go to court, because we will see much faster legally binding final decisions by the courts. We have already initiated our first proceeding in this respect, that is with regard to Facebook and the linkage between Oculus and the Facebook account. We have reshaped our internal structure a little bit. So as I said, we're just taking breath now, getting organized, planning our cases, and then you will hear from us.
Okay, so we'll probably even hear a little bit more about this a bit later, perhaps in the Q&A. But thank you very much for that, Andreas. We move now to Cani Fernández, president of the CNMC, the Spanish Competition Authority. And I know that you have many actions in the pipeline on the advocacy front. And can you tell us what they are and the timing for them?
Thank you very much. I hope you can hear me well. It is true that, advocacy efforts in favor of pro-competitive reforms are of particular importance to cope with the current crisis and boost a strong, sustainable and inclusive economic recovery, especially since most countries, as Spain, have a very narrow margin to apply additional expansionary fiscal and monetary policies. So in our working plan, our biannual working plan from 20 to 21, we have assumed a commitment to take a step forward in promoting further the development of a competition culture in Spain, while at the same time maintaining our ambitious line of research in sectors where competition outcomes are not satisfactory, with a special focus on the challenges brought by the economic crisis and the digital and environmental transformations of our economy. Those are the lines of our strategic plans. Therefore, on the one hand, our working plan for 21-22 includes a number of guidelines aimed at promoting competition culture, addressed not only to the general public, but also addressed to the government, public officials, and policymakers. And regarding those that are addressed to the general public, we believe that they are essential because we agencies know that competition is essential to promote economic recovery, but the general public does not. Because the channels through which the positive effect of competition is transmitted are indirect, and sometimes the messages are difficult to understand. Therefore, competition agencies have to be pedagogical in conveying the message that competition benefits the consumer, and that is why we are publishing guidelines on benefits of competition for consumers, where we explain in an accessible language what is a restriction of competition, why it is illegal, and which are the benefits of well-regulated and efficient markets for consumers. We are drafting a study on the role of competition for a sustainable economic recovery, how competition will help in this task. And we are finishing a study on the relations between competition and labor markets that will explain the positive links between competition and labor outcomes, such as employment, wages, and other working conditions, based on economic consensus from institutional and academic research. Regarding guidelines that are aimed at promoting a competition culture addressed to government, public officials, and policymakers, we believe that in this context of economic recovery, it is essential to remind the public sector of the importance of competition and the simple and practical ways that exist to improve competition in the attainment of their public goals. And thus, we are working on some updates of our guidelines on public procurement. The previous one dated 2011 and were mostly on planning. Now the update is working on preparation, on contract awarding, and also on contract performance. We are also working on some guidelines on do's and don'ts in regulation, procurement, and public aid that are addressed to policymakers and also the government, and that will include general principles and recommendations about how to accelerate a strong, sustainable, and inclusive economic recovery in both regulation, public procurement, and also state aid. We are elaborating as well some guidelines on do's and don'ts to remove local barriers to competition that are addressed to local authorities in order to tackle barriers to competition that we often see in municipal activity, for example, in urban planning or licensing. And those will include a review of some specific common problems that are fragmenting the Spanish market due to the introduction of local regulations. We are also undertaking a number of market studies, also in our action plan. The fundamental objective of market studies is to improve the framework for public intervention. We have a methodology for our market studies in which we describe how a market study is conducted and how to identify sectors worth studying. Because we have very limited resources, we focus on sectors with an important impact on consumers and the economy as a whole. We always listen carefully to consumers, firms, academics, and policymakers to identify areas in which a market study can be useful, and we have a mailbox where anyone can suggest a market study. Some of the market studies that are focused on helping a sustainable and inclusive economic recovery We are concerned about the economic sectors where there is a great number of vulnerable consumers and they are exposed to situations with a lower degree of competition. So we are going to make a special emphasis there. We are also addressing on market studies some digital challenges that we are facing. For example, we are now on the edge of issuing a study on online advertising, for example. And we are also addressing some environmental challenges through market studies as well. So those are, I would say, what we plan to do in the short term. Thank you.
Thank you very much, Cani, for that very wide sweep of advocacy efforts that you're doing. Curious to see all of that output when it comes out sometime soon. So thank you, Cani. I move now to Rebecca Kelly-Slaughter, the acting chairwoman of the US FTC, and curious to hear what the US FTC has been up to in these as regards competition policy or advocacy in the current context of towards the economic recovery. So welcome.
Thank you so much, Ruben. It is really such an honor to be here with such a distinguished panel of colleagues, and an honor to be here in my role as acting chair of the FTC. I will note, of course, that even as acting chair, I have 3 other colleagues who are also commissioners on the agency and who may have strong views of their own about these issues, but I'm excited to be able to share mine because I think these questions are really, really important. And the whole framing that you have set up here about the role of competition in the response to the COVID crisis and in the economic recovery that we are either undertaking or about to undertake, or to which we are all dedicated, is something that's a big priority for me. I have thought a lot about how we can use the FTC's tools across our mission area, competition, consumer protection, things that cross both lines, in order to contribute as much as possible to an effective response to the COVID crisis. And I think that the questions of competition, both advocacy and enforcement, are an important part of that. So I'm going to focus my comments in the advocacy section today on 2 particular issues having to do with advocacy to the markets that we are making. I worry in the economic reaction to the COVID crisis about 2 particular kinds of opportunistic economic conduct that we as competition authorities need to guard against. The first, several of my colleagues here have already raised, which has to do with labor markets, and the second has to do with opportunistic acquisitions. And so on the labor market point in particular, I will note that last April, DOJ, working with the FTC, issued a statement to the markets warning that enforcers are going to closely monitor improper employer coordination that may disadvantage workers. The statement affirmed the application of antitrust laws with respect to hiring and employment, and that they remain fully in effect during the crisis, and specifically said that COVID-19 does not provide a reason to tolerate anti-competitive conduct that harms workers, including doctors, nurses, first responders, and those who work in grocery stores, pharmacies, and warehouses, among other essential service providers on the front lines of addressing the crisis. And I think that that warning remains really important and very operative for markets. And in particular, that we are going to focus on preventing employers, especially healthcare staffing companies and recruiters, from engaging in collusion or other anti-competitive conduct in labor markets, such as agreements to lower wages, or reduce salaries or hours worked. So that's one important part of advocacy, making sure that markets understand that we are watching, we are on the job, and conduct that takes advantage of some of the labor market crises, constraints that we are seeing is something that we will not tolerate simply because of the crisis, and in fact are perhaps more attuned to it. The second point I want to make is about opportunistic acquisitions. At the beginning of the crisis, we saw a big drop in merger filings. But over the last 6 months, those filings have not only resumed normal levels, they've actually picked up to extraordinary levels. We are at very, very high levels of merger activity in the United States. And that is something that we are sensitive to, both on its own, but in particular, thinking about how companies might try to take advantage of the economic crisis to scoop up competitors in acquisitions that might otherwise, that they think we might otherwise have a problem with. And I want to make clear that if we would have had a problem with it before the pandemic, we will still have a problem with it now. Even before the pandemic started, we were seeing an increasing number of companies claiming failing firm defenses. And under US law, failing firm is a very specific legal structure test that companies have to meet in order to make an otherwise anti-competitive acquisition pass legal muster. Those standards are not relaxed. We are going to continue to look to make sure that if a company is claiming a failing firm defense, that it actually meets that legal test, and that we do not see the pandemic becoming a roll-up opportunity for large companies to get even larger when their competitors are struggling. So I want to focus on those two things because I think those are really important signals that we are sending to the markets, in addition to coordinating with other government enforcers at the state, federal, and international level to think about some of the bigger picture issues that we've discussed today.
Thank you very much, Rebecca, for that very interesting look as well at what you're advocating for in the current circumstances. I think that finishes our competition policy advocacy subsection, let's say. We move on to the enforcement side of things. We've touched on enforcement already a few times, but I think I'm going to ask my speakers to exercise extreme discipline on time. I know that I was a bit more relaxed in the first round, but we are running out of time and I would like to have some time for questions. So we still can probably afford around 25, 27 minutes. So we still have a good time, but please, let's do that. I wanted to start with Andreas this time. And you mentioned cooperation agreements, that you are more relaxed towards cooperation agreements than you were, for instance, and relaxed is the word you used, than you were with merger control. And I know that the Bundeskartellamt has a very interesting case that you talked to us about in the competition committee in December in the automotive industry. Could you tell us about that case and how the Bundeskartellamt was involved in that case? And also to what extent perhaps you think that might have been different without the crisis? So you have approximately 4 or 5 minutes, please.
Yeah, sure. Ruben, thank you very much. Well, we have a long experience. We have been given advice on corporations here in the Bundeskartellamt for a very long time. That has a long tradition. It was more intense, more urgent during the crisis, but we have tried to support companies and associations as much as we could. One of the bigger cases on which we had to give advice in these times was a case presented by the Association of the Automotive Industry. And that was about how to restart the automotive production after the shutdown during the first wave, and how to set up a model for restructuring suppliers who might not survive and who might got out too badly after this crisis. I mean, it was pretty clear that in complex supply chains, downtimes at individual sub-suppliers can cause great economic harm. It can delay the restart of the production at the manufacturer. So there was a point for debate. In the very end, we wrote a comfort letter to the association, and there were a couple of features that were quite important for us during that time. Important was that suppliers remained free to choose when and how they wanted to restart their production, that they were not obliged to restart at a specific point, that the best practice guide would not contain any company-specific information relating, for example, to amounts or goods of contracts. So we did not want to implement a very transparent market transparency scheme during that time. For us, it was important that existing contractual obligations remained unaffected. What was important to the association, that given that the fact that there was a shortage of supply, that the suppliers were not obliged to supply those who paid best, but that there was a proportionate supply to the OEMs, the original equipment manufacturers, along a proportionate part of how they had supplied these OEMs before the crisis. That was in order to make sure that all OEMs at the same time could restart production and not just leave it to the one who paid best for parts during that time. Maybe these were kinds of agreements that would be a no-go in usual times. But I think during that time, it was adequate and appropriate. We also took care, of course, that this process was limited in time, that there was no information exchange, and so on, all these kind of things. So, in fact, our headline always was that this coordination had to be appropriate, proportionate, non-discriminatory, and limited in time. By the way, something that could also be or should be true for state intervention. If state intervention as well, subsidies and so on, was always appropriate and proportionate, non-discriminatory, and maybe even most important, and that is my key point, limited in time to the crisis. I think then you can go for lots of things during a crisis if you make sure that this comes to a strict and safe end once the crisis has come to an end. So I think this is not only true for tolerating cooperations and coordination among companies. I think this can also be true for state intervention during the crisis. Get out of it as a state once it is done. Thank you.
Thank you very much, Andreas, for a very succinct but to the point and keeping to your time. I do think that's a very interesting case. And in particular, it does show, because such an important industry, of course, in Germany, how that close coordination, let's say, or look at what was happening, actually allowed then the automotive sector to remove itself from the confinements of the confinements and move ahead back into production. So, and for the economic recovery, therefore.
Of course, in Germany, it had to happen in the automotive sector, where else?
Exactly. Okay, so thank you so much, Andreas. Excellent points. Margarida, can I move to you and also, kind of linked to cooperation or to the limits of cooperation, let's say agreements and enforcement. And you mentioned a number of cases, you alluded to a number of sectors there. You mentioned connectivity, labor, and so I was wondering whether you had also enforcement actions in those areas of priority that you could share.
Sure, thank you, Ruben. Our enforcement, as you said, in 2020 and now also in 2021 has followed closely the insights I mentioned earlier, and that was connectivity or communications, labor markets, state intervention. So, for example, to give you some of our enforcement cases related to this. We had in 2020 an important action in antitrust enforcement in the telecoms and digital sectors. One of them was last December when we sanctioned one of the largest telecom operators in Portugal. And this was for having agreed with the competitor to increase prices, reduce quality, share markets. Another enforcement action we had was in earlier in the year, in July. We issued a statement of objections to the 4 major telecom operators in Portugal for participating in a cartel where they agreed not to advertise online next to each other. So it was telecom / digital. And in this preliminary conclusion, we found that the agreement had limited competition amongst telecom operators within the advertising space that exists in Google's search engine. So therefore, reducing the incentive to compete and present better deals to consumers. So the ADC's focus on the digital economy through its dedicated task force will continue, because the risks of collusion and other anti-competitive behavior have, in our view, significantly shifted very recently in the last year from bricks and mortar to the online environment. This was already, of course, undergoing, but it shifted, in our view, very radically in the last 12 months. So following up on what I said earlier, another priority for this year is labor markets. And as I said before, there is a need to be free of unnecessary barriers, but also of anti-competitive behavior. So in May last year, we opened an investigation regarding a no-poach agreement that was made public, and we issued an interim measure to cease that behavior. The investigation concerns an agreement between the Portuguese Professional Football League and the male professional football clubs in the first and second league. The clubs had agreed not to hire each other's players who unilaterally terminate their employment contract. And as I said, they made this public. And I think what is important here is that no-poach agreements in any sector may reduce the flexibility of labor markets and distort competition. And this is even more important in the context of economic recovery. By the way, we also issued a recommendation regarding the female football league that this federation had wanted to set a salary cap for these football players. But following our recommendation, they withdrew it. So that was important. It may also be worth mentioning how we have dealt with the forms of cooperation that you were mentioning earlier arising from the pandemic. For example, in the banking and financial sector, we issued written guidance to the Portuguese banking and consumer credit associations. This guidance related to the adoption by these associations of the main conditions for moratoria or loan payment suspensions, which were going to be applied by their members, so banks and credit institutions, other credit institutions. By the way, this was also an action that had been encouraged by the European Banking Authority and by the Portuguese Central Bank in order to allow banks to temporarily support debtors without affecting banks' prudential obligations. We warned specifically about the risks of exchanging confidential information. We also stressed that banks and credit institutions should remain free to grant their clients more favorable conditions than the ones set under these moratoria. The takeaway for us is that crisis management may prompt competitors to engage in new forms of cooperation with the support of public authorities without of course, understanding the implications for competition. But the enforcers must remain vigilant towards opportunistic behavior that, in the end, may hurt consumers in the economy, not only in the long run, also in the short run. So I'll stay here.
Thank you very much, Margarida, for those insights on the actions that you've taken so far. I think maybe this is probably a good entry into to Cani Fernández, who I believe that the financial system there also, of course, plays a key economic role, of course, and what kind of actions, I know that the CNMC has been looking at this, is what kind of action is taken as regards the credit needs to ensure that they are met in the economy. And also I know that to have a quicker answer on the public procurement work that you've been doing and Vidrik, that you also mentioned in your initial remarks.
Thank you very much. Yeah, it is true that at this time of crisis, it is necessary for credit to flow in economy. And even more so in an economy like the Spanish one, where SMEs and the self-employed account for a significant part of our economic structure. So following on the complaints that we received during the first pandemic wave through the COVID mailbox, a mailbox that we set up to centralize all the complaints and queries related to the enforcement of competition rules in the context of the COVID outbreak, we are now monitoring the possible bundles with other products such as insurance products or alarm services or other imposed by the banking entities in the granting of these eco credits or ICO credits. These ICO credits are from the Official Credit Institute. It's a public financing line put in place to immediately address the problems arising from the pandemic. We immediately contacted the banks to stop any possible obstacle to the access to financing by companies and in particular SMEs and self-employed. Likewise, we are carefully analyzing the mergers between banking entities, currently CaixaBank Bankia, but others are to come. This one, CaixaBank Bankia, will become the largest bank in the Spanish market with assets of more than 660 billion euro. And we want to ensure that we will have a solvent and competitive financial system after the mergers, which will allow us to continue giving credit at this time when companies need it most. As for public procurement, well, again, in times of crisis, it becomes even more necessary to make efficient use of public resources. And as a competition authority, our role is to avoid any possible manipulation of public tenders due to anti-competitive agreements. In 2019, the CNMC created the Economic Intelligence Unit, which aim was to boost ex officio detection of cartels, especially those affecting bid rigging in public procurement, and also to assist other units in issues related to inspections or their specific cases. But this unit has a multidisciplinary staff composed of mathematicians, lawyers, economists specialized in competition, quantitative techniques, and forensic IT people, big data analysts. The first investigations undertaken by the Economic Intelligence Unit are now bearing fruit. The radiopharmaceuticals case has just been resolved in February 2021, so this month, sanctioning the two main producers of PET radiopharmaceuticals for a market sharing agreement. As you may know, radiopharmaceuticals are used in nuclear medicine. They are used in tests by hospitals in order to detect and monitor diseases such as cancer. This case originated through the work of the Economic Intelligence Unit and deals with, as you may know, an especially sensitive sector at the moment. Our decision, which is of course subject to appeal before court, shows how the two companies now sanctioned adopted a shared strategy to distribute a large number of contracts for the supply of radiopharmaceuticals to public and also private hospitals located in various regions in Spain. Very serious infringement under Article 1 of our law, but also 101 of the Treaty of Function of the European Union. The decision also triggers the procedure to determine the duration and scope of the prohibition to participate in public procurement by these two companies. This prohibition results from the infringement declaration, and it introduces a very valuable element of deterrence, in particular in the current economic scenario. We believe this is a key issue now, and during the next years, since the public sector is expanding its role in our economies, and thus it will increase its procurement needs, and also because firms will rely more on public demand due to the economic crisis. Last, to say that in this respect, our Economic Intelligence Unit, along with the Advocacy Department in the CNMC, are providing training programs to public sector officials that allow those public officials to design high-quality public procurement strategies to fight bid rigging and also to detect possible collusion. We've already trained over 1,000 public officials. Thank you very much.
Thank you very much, Cani. Some very interesting insights as well on the public procurement and the importance that it will certainly have, increasingly so, given the increased role of the state that we'll probably see following all the state interventions that we're analyzing, that has been already pointed towards in the previous presentation as well. I'd like to, so thanks, Cani, very much. I'd like to move to Rebecca and to understand what the US FTC, how it's been handling its enforcement work, in particular with the view to specifically the economic recovery. So Rebecca, you have the screen.
Yeah, thanks, Ruben. Well, I mentioned when we were talking about advocacy that our merger filings have been historically high. I think it's also important to note that our enforcement activity has been historically high too. In the last year, we filed about a dozen different litigation complaints in addition to a number of settlements of merger cases. And our complaints go to both mergers and to conduct questions. Some of them have nothing to do with the pandemic or the recovery, but I think that that's important too. In industries like personal care or e-cigarettes, we have filed litigation challenges, but that is to say that we are continuing to monitor and will continue to enforce in areas across the economy. Also, of course, we filed our big Facebook complaint in December, and that's a conduct case. So those issues are ongoing. Some of our challenges are directly related, if not to recovery, but to COVID response in some way, to the extent that, for example, we filed 3 hospital merger challenges. Healthcare access and healthcare pricing is a really important part of our COVID response. And when we see mergers that could limit access or increase prices in the healthcare space, that's something that we take seriously and need to prioritize. It's been a historic priority for the FTC. It continues to be a high priority. And the only thing I'll add, I'm trying to be succinct in going forward, is that I think in addition to prioritizing healthcare areas, I want us to be thinking about other supply chain critical markets where we see consolidation and want to make sure that we are doing our part to preserve supply chain resiliency or to create some supply chain resiliency, because resiliency is really negatively affected by monopoly, right? Monopoly in supply chains is a problem for our recovery. And so making sure that we're applying competition law and prioritizing cases where we can that affect critical supply chains is a big priority for me.
Okay, thank you very much. That was indeed very succinct. So, and very interesting comments as well on resiliency, one we haven't heard yet so far so much during this panel, but it's certainly a very important one, as we've seen that value chains have suffered quite a bit in the current context. So I'll pass. So thanks, Rebecca. I'd like to pass on to Olivier, and with more of a you mentioned, Olivier, in your initial remarks on advocacy, the importance of innovation and the importance of state support in that context. But I was wondering if you could say some words about innovation and the role it can play in the recovery, and in particular, when you look at how you can contribute in the context of more enforcement cases, and how you can look more at this, or what more towards this objective, let's say.
Yeah, thank you. I try to match the others in terms of being succinct throughout all 3 instruments. Well, let me maybe start, because this is where the track record is clearly established for antitrust. So Article 101 of the treaty and 102, where I mean, really a key focus or theories of harm in the recent past, in particular in the tech environments, has been an innovation harm theories. And well, you see it in the big platform cases, that's very obvious, but also many other cases. And that goes also in terms of helping to innovate, as I said, in order to match or overarching goals in terms of decarbonizing the economy, etc. The flip side of it is, of course, also how can you take account of positive efficiencies and externalities in the balancing act under Article 101.3. So balancing the harm to competition with the positive macro impact. That's not a trivial question. It's a question with all the European colleagues around this virtual table we're thinking about in the framework of the ECN. Should you take so-called out-of-market efficiencies into account? To what extent? We have different views on this, on these aspects. Should it be the same constituency that is harmed by a practice that benefits, or is it immaterial? Let me take an example. I mean, assume you have an agreement outside of the union to reduce gas emissions, but of course, the clear result of that agreement is raising of prices for European consumers. How do you balance this out? Can you balance this out at all? So a number of really fascinating questions in that respect, which are very much in the making. Second area is merger. In merger, the weight of innovation theories of harm is ever increasing. I mean, we have more and more cases. The great contributors are the pharmaceutical sector. I mean, we have cases like in oncology medicines, for example, Novartis, GlaxoSmithKline's case, Pfizer, Hospira case, Medtronic, Covidien. We have many, many cases. Second big contributor is agrochemical industry. So you will find such theories of harm based on innovation harm in Dow DuPont, for example, or Bayer Monsanto. And quite recently also, we developed it in the nuclear, which is quite totemic in terms of green. So in General Electric Alstom was also based partly on innovation theories of harm. And it's interesting because here really there is a direct link with the Green Deal. The Commission had concerns that absent adequate remedies, the measure would have led to a decreasing of innovation and higher prices in something that's called heavy-duty gas turbines. And that is a technology that is a vital transition in order to meet the climate neutrality goal in 2050 for Europe. So we selected the remedy taker with this in mind. It was an Italian company, Ansaldo, and they successfully finalized the development of the divestment business. And after that, they successfully won bids against Siemens and actually were an engine for innovation competition in the market. And the last sector, of course, is state aids. As mentioned it in my first remarks, green conditionality is going to be more and more important with a focus on both innovation and market failure. This is clearly where we're going to. And very quickly here, the case at stake is, for example, IPCIs. So IPCIs are basically projects in which none of the companies, there is a market failure because nobody can make it on its own. Like, for example, developing batteries production on European soil, or moving to hydrogen, and in particular green hydrogen. Why? Most often because there is a first mover disadvantage, so you need to have some form of coordination, and or because the market alone cannot make it, so simply too expensive, or none of the companies has the resources on its own. And this is where IPCIs are quite powerful, because then you combine both a state aid where it's necessary, together with some form of antitrust immunity, because of course we cannot allow a state aid for something that would infringe on our antitrust rules.
Okay, thank you very much, Olivier. I need to kind of finish off where we started and where we did a kind of a full circle, even with Mariana Mazzucato's and the conditionality and the market failure. So we took a very much a broad view, and we saw a lot of different activities of competition authorities, different ones. Different actions, different priorities, also defining different ways that the economies, of course, are built. There was maybe one sector which seemed to converge some jurisdictions around the table, which is the digital one, where there, definitely clearly an area where we can see probably quite important for the economic recovery as well. We're going to have to close, so unfortunately there will not be time for questions, but I did want to leave you with a provocation which came from a question that we got asked by Calvin Goldman, who you might know from BIAC, and he asks the competition authority, I wanted to ask a question, but I'll leave the provocation instead, which is in a context where there's so many job losses, and where mergers can actually lead to job losses, and that eventually they might even be seen as some sort of efficiencies in certain instances. How should competition authorities around the table think about this? So I'm not going to ask you a question unless someone wants to come in with a 30 seconds response to what is a very difficult question. But I do think it was a good way to finish, because it is an important element for competition authorities to consider. Certainly will be fundamental. We've talked about labor markets quite a bit today as well. I wanted to thank you very much for your time today. Great pleasure and honor to have you here discussing with us. We certainly heard you with a lot of interest, and I think this is probably a debate that needs to be enlarged and continued as we continue to look towards a recovery. Andreas, you were a little bit hopeful that it will come, but not so confident that we're there yet. Probably right. But probably there's a lot of issues that are coming in the next few months and years, and probably worthwhile continuing this open line. So once again, thank you so much, everyone.